All right, well, we've got a good crowd here. I say we launch into things. I'm going to kick things off. My name is Becca. I'm an organizer for UAW Member Action, and this is Winning the Tough Discipline Case, Attendance and Insubordination Write-Ups and Testing for Just Cause. So first off, what is UAW Member Action? We're a network for UAW members. We want to get the membership more engaged in fights for stronger contracts, better contract enforcement, and using democratic rights to make positive change at all levels of the UAW. Who is this webinar for? All members are welcome here, and you have an important role to play in sharing information with your coworkers, helping enforce your contract, and holding your reps accountable. This class is going to be especially helpful for you if you are a grievance handler yourself. And there are some different names across the UAW for grievance handlers in different shops and locals. So you might be a steward, a committee person, a shop chair, a district, an alternate. We're just going to refer to all these titles as a steward for the sake of brevity throughout the training. So let's look at the agenda for today. We're going to start off with the legal background, testing for just cause, and then we're going to get into some practical tips for dealing with attendance write-ups and insubordination write-ups. Then we're going to finish with some time to ask our presenters questions about what we learned. If this isn't your first webinar with us, you already know how to use Zoom polls. We like to use these throughout the class to keep you on your toes. But in case it doesn't come up when we launch a poll, you can still access it manually. You want to swipe along the bottom menu to the right, click More, and then click Polls and Quizzes. So we're going to try a practice round, and in a few moments, you should see a poll pop up on your screen, and this is the time to let us know if you're having any questions. Okay, so I just launched the poll, and you should see the poll on your screen now. Okay, I'm seeing that most people have been able to respond. Let us know in the chat if you're having any problems. Okay, it looks like almost everyone's been able to respond. So we're going to end this practice poll, and we're going to get into introducing some of the presenters. So first off is Will Bloom, who's a labor attorney and former member of UAW Local 2320. He's with the firm DePrez, Schwartz, and Gagan. Next is Brandon Kluklevich, who's an alternate committeeman in UAW Local 897 at the Ford Buffalo Stamping Plant. And finally, we got George Freeman III, who's the UAW Local 933 unit chairman for Allison Transmission in Indianapolis. And without further ado, I'm going to kick it over to Will to get us started.
Hi, everyone. Thanks for joining us this Sunday afternoon. I am going to start today's training by talking about the concept of just cause, the principle of just cause, which is far and away going to be the most important concept in any disciplinary matter that you might face as a steward or committee person at your job. This is a concept that's going to be found in, I'm willing to bet, every single one of your contracts. As a provision in collective bargaining agreements, it goes back 100 years. It's been showing up in CBAs basically since the beginning of American labor law. But for a long time, that term was ill-defined and not particularly well understood in any kind of common way. For the first few decades of the modern kind of American labor law regime, just cause was basically just a principle of the arbitrator knows it when he sees it. But starting in 1966, in a case called Enterprise Wire, arbitrators started trying to create a body of law, a set of principles to apply to determine whether or not just cause was followed in any kind of disciplinary action. And kind of the key question here is what was the reason for the action? What was the cause? And was that a just cause? Was that a good reason? Um, Today, as the slide says, just cause provisions can be found in the vast majority of contracts, over 90%. They are applied normally by the arbitrator or the umpire, whatever it's called in your situation. And it's going to be the meat of whatever kind of legal argument, whatever kind of argument based on principle you're going to apply to the facts of a particular situation. I mean, yeah. And it's important to understand what the alternative to just cause is. I don't know. I think probably if you're in a union, you may not have had this experience for a long time, but the alternative to just cause discipline is at-will employment, which is the idea that an employer can take negative action towards you or even fire you for any reason or no reason at all, just as long as it's not an unlawful reason like, race or sex discrimination. Unfair or arbitrary firings affect close to half of workers at some point. And it is that fear of retaliation is really one of the biggest hindrances in getting workers to stand up and fight back. So, we as union members, as UAW members, have a responsibility to protect just cause, to make sure that our coworkers feel those protections, because making sure that just cause is actually followed and that we and our coworkers enjoy and kind of innately understand that we have those protections is fundamentally important to making sure that our coworkers feel able to stand up and fight back when issues arise at work. So this is, a floor that all of your organizing is really built on. If we go to the next slide. So there's 7 basic principles of just cause. These have been developed over the last 50 or so years by arbitrators. Like I said, this is kind of, what in lawyer world we call judge-made law. Here it's arbitrator-made law. It's not like there's a statute that Congress passed that said these are the principles of just cause. These are principles that have been developed by arbitrators over many decades. Some arbitrators will apply them a little differently. But the 7 principles we're going to talk about today are probably going to find sway, are probably going to hold sway, are probably going to find currency with pretty much any arbitrator that you are arguing in front of. And so we'll start going through them. So our first principle is the principle of fair notice. An employer may not discipline an employee for violating a rule or standard whose nature and penalties have not been made known. And this, as most of what we're going to talk about today is, this makes a lot of sense. This just kind of seems, like common sense. You can't enforce a rule against someone who didn't know that rule existed, or didn't know what would happen if they broke that rule. So, for example, an employer cannot discipline an employee for taking a call at work on his or her cell phone if the employer never notified employees that this was not permitted. There are the whole point of having work rules is to have people comply with them. And if the employer never told you and your coworkers about that rule, how can they possibly expect you to comply with them? Now, as with all of the principles we're going to talk about today, it's never as simple as it seems on face value. For instance, this fair notice rule doesn't apply to self-evident misconduct, theft, insubordination, fighting, or sleeping on the job. An arbitrator, if this is you can't pull an Air Bud here and say, well, there's nothing that says a dog can't play football. If your boss never told you, hey, actually, it's not okay to beat up your coworkers, you can't use that as an excuse for beating up your coworkers. An arbitrator is going to say, come on, you knew you couldn't do that. So that self-evident misconduct caveat is an important one to know. The other thing that's important is that an employer can publicize these rules in a variety of ways. One of the most common ones is an employee handbook or, a presentation during new employee orientation. But there's also physical distribution, handing out, little flyers saying, by the way, this is a rule, putting it on the bulletin board, emailing people, meetings, classes. But it's important that that rule be sufficiently clear as to put workers on notice of what the rule is actually prescribing or requiring. They can't be so ambiguous or vague that a reasonable employee wouldn't know what it means. So, for instance, A rule that says no boisterous conduct or don't engage in poor judgment, that's not going to be clear enough for anybody to know what they're being told to do or not do. So that's a burden that the employer has, and if you find yourself in an arbitration, you can make the argument that they failed to meet that standard of clarity or lack of vagueness. We can go to the next slide. So yeah, the second principle that we're going to talk about, which is related in some ways, is principle of prior enforcement. An employee may not be penalized for violating a rule or standard that the employer has failed to enforce for a prolonged period. This is basically a concept of use it or lose it. If for a long time an employer simply does not enforce a rule, employees will be forgiven for thinking, well, I guess this rule doesn't apply anymore. And especially if that rule is notoriously openly broken by employees, and they face no consequences, that that is the employer sending the message to employees, it's fine, this isn't a real rule anymore. This kind of goes to a principle of due process that we'll talk about in a little bit, of equal enforcement that we'll talk about in a little bit. But we'll talk about that in a little bit. So the example we have here, an employer may not discipline an employee for coming into work a few minutes late one day if the employer hadn't enforced this rule for a long time and was aware of other employees coming in to work late. Now that second part about awareness is really important because if the employer can argue, well, everybody may have been violating this rule, but I didn't know about it, then you're going to have a hard time establishing a lack of prior enforcement because they're saying it's not that we weren't enforcing it, it's just we didn't know. So it's going to be important to be able to show, one, that the employees ignored the rule without penalty for a prolonged period. It can't just be a one-off thing, it has to be over a prolonged period. And that management was aware or reasonably should have been aware of the infractions. So, if the employer had a don't ask, don't tell policy, or if there was a no cell phone rule in the workplace, but anytime a manager saw a cell phone, they just did one of these, those are things that show that the employer knew what was going on and declined to enforce it. Now, an important consideration here as well is the ability of the employer to reset. So, if there's a rule that has gone long unenforced, you can't be disciplined for that. But the employer is well within their rights to reset things, to, send out a memo, call a staff meeting and say, hey, I know we have this rule on the books, we never enforce it. That changes starting right after this meeting. We're going to enforce this rule. From that point on, they can enforce the rule as if there were no prior enforcement issues. So it's important that if that happens, that you and your coworkers know that a prior enforcement argument is probably not going to work out for them. So I think on the next slide, we have a poll for you, which I'm going to ask Becca to start up. The supervisor in your department has not enforced a rule in years, but management elsewhere in the plant has enforced the rule. Can you make a strong case that management does not enforce the rule for workers in your department?
Okay, everyone, you should see the poll on your screen now. If anyone's having trouble, let us know in the chat. Looks like most people are chiming in with an answer. Gonna give it 10 more seconds or so. Great, okay, I'm gonna wrap up the poll and share the results with everyone.
All right. Yes, I will say, as a lawyer, the answer is always it depends, but yes is basically the right answer here. Yeah, I think it depends on the specifics of your particular plant, of what distinguishes the part of the plant where they didn't enforce the rule from the rest. But yes, the basic principle here is, does a worker, does a given worker, does she know that this rule is actually going to be enforced against her or not? Because if a worker has the sense that it is not going to be enforced against her, and that sense has been given by management, management cannot turn around and enforce the rule. It basically is a version of that prior notice principle that we talked about in the first instance. And so in the case of the individual worker, or the individual grievant, if you can show this person experienced a lack of enforcement over a prolonged period, and management was well aware of that lack of enforcement, That's going to go a long way to making your case. Um, all right, our next principle, which is perhaps the most complicated and also most interesting of the pile, is due process. An employer must conduct an interview or hearing before issuing discipline and must act promptly. Once assessed, discipline may not be increased. So due process is kind of a catch-all term. It comes from the kind of British common law tradition, Magna Carta and all that. And it's basically the idea that in a disciplinary process, the accused is entitled to certain protections and is entitled to a process that is fair, entitled to process that is due to them. Like I said, this is kind of a few different ideas bundled together. We'll show an example here, which gives some sense of that. A supervisor cannot issue a written warning one day and then decide the next day to issue a suspension over the same incident because they were reprimanded by upper management for, quote, letting the employee off the hook. So this speaks to the last of the three kind of items in the bundle that you see in this slide. If we go to the next slide, we can talk about some of the more specific aspects. Um, Employers must provide employee with a notice of the charges against them and an opportunity to explain before discipline is imposed. This first piece is very important. You can't just vaguely be told, well, you engaged in conduct unbecoming or something like that. An employee is entitled to know with enough specificity what they're being accused of, with enough specificity to respond, to say that's not true, or to say, well, here's what happened. But if they aren't given enough information to know what exactly they're claiming they did wrong, then how can they respond to that? And related to that, they actually need to be given that opportunity to explain what's happening. Sometimes it takes the form of a Weingarten interview, of an investigatory interview. Sometimes it's a more formal process in some workplaces, but some kind of opportunity needs to be given. Now, importantly, the employer may be excused from conducting an interview if the evidence is so conclusive and the misconduct is so egregious that nothing the employee could say could affect the outcome. Again, this goes back to the, beating up your coworker in the workplace. If that happens in front of a manager, they're probably going to get away with not holding a hearing like this. But related to this is the principle of one-time penalty, which we'll talk about in the poll in a second. But the principle of one-time penalty is once discipline has been imposed, it can't be escalated based on the whims of senior management. And we'll talk about progressive discipline in a bit and the purpose of discipline. But to impose additional discipline for the same instance after discipline has already been imposed undermines that principle of due process. So next up, we have a poll, increased penalty. If the employer discovers new information about an incident they have already issued discipline for, can they reissue discipline and or increase the penalty?
Okay, you should see that poll up on your screen. I'm seeing most people are responding. So we'll just give it 15 more seconds or so to think about your answer. All right, now I'm going to end the poll and pass it back to Will.
All right. Answer no here. So the genuine and truest answer, not just my lawyerly answer here, is it depends. This is a very complicated case. The general principle is management can increase discipline if additional evidence that was unavailable at the time of the initial investigation comes to light. If they learn something new that they could not have obtained at the time. Well, more specifically, unavailable means was withheld by the union or the employee, was hidden by them, or was genuinely unobtainable. It was a security camera footage that another employer had that they had no way of accessing, something like that. Now, if it's information that they really reasonably should have gotten and just didn't, if they did a lazy, lackluster interview, then you have an argument that that's not really new information that was previously unavailable. That's just them doing a shoddy job. So this is a real it depends answer in the truest sense of the word. I'm sure the specifics of what happened in your situation in any instance like this will dictate a lot about what the answer is to this question. Yeah, a little more on this principle of due process. Employers must take disciplinary action in a timely manner. An employer can't just sit on an accusation for a year and then break it out at a moment that's most opportune to them. Um, this is for a variety of reasons, not least that it's much harder to mount your response to a charge that the employer has been able to, cook up for months and months and months before even telling you about it. Again, employers must give the employee precise statements of charge. And again, this principle that an employee cannot be disciplined twice for the same misconduct. All right. Our fourth principle, substantial evidence. This is a seemingly basic principle with some complicated principles underlying it, but the basic principle here is charges must be proven by substantial and credible evidence. There are three standards that can be used when we talk about substantial evidence. And again, this is what's going to be applied is dictated by your contract, and to the extent your contract doesn't specify, by the arbitrator. But we'll talk about what's most common. We'll start with what's least common. What's least common is a beyond a reasonable doubt standard, which requires the employer to prove guilt. This is what you'll see in court hearings for criminal charges. This is the standard for a criminal conviction. It's pretty rare for this to show up in arbitration, but it's worth just mentioning that this is one of the standards in question. The second, to a moral certainty or clear and convincing, requires evidence that is corroborated, consistent, and precise. This is something less than beyond a reasonable doubt, but something more than preponderance that we'll talk about in a second. Again, this is not the most common thing you'll see in an arbitration in a disciplinary case, but sometimes you will see arbitrators apply this standard when the violation that underlies discipline is also a criminal act. They don't want to quite so easily make a determination that a criminal act occurred. So you might see that in that kind of situation. And then our third standard here, which is the one you will encounter far and away the most often in arbitrations, is the preponderance of the evidence standard, which is satisfied if the evidence is more likely than not. Basically, it's the arbitrator will take all the evidence weighing in one direction, take all the evidence weighing in the other direction, and whichever side has more weight, that's who wins. It's a 50% plus one standard. That is far and away the most common thing you will see in a disciplinary case. It's the standard in most civil court actions. So a wage theft lawsuit or discrimination lawsuit, those kinds of things. This preponderance of the evidence standard is most common. All right. So the next principle, equal treatment. Unless a valid distinction justifies a higher penalty, an employer may not assess a considerably stronger punishment against one employee than is assessed against another known to have committed the same or substantially similar offense. For example, an employer cannot discipline one employee for taking a long break if it didn't discipline another employee who also took a long break. This is a basic principle of just cause, that the idea is that the discipline is not arbitrary, that it is tailored, that it is intended for a certain purpose, and that it makes sense and is explicable and understandable both after the fact and to an extent before the fact by the person being disciplined. And that's because, as we'll talk about in a second, discipline in the workplace under a collective bargaining agreement under principles of just cause is meant to be corrective. It's not meant to be punitive. It's not meant to punish someone for doing something wrong. It's meant to nudge them in the right direction to do the right thing. So yeah, to dig into this principle a little bit, disparate treatment occurs when a markedly harsher penalty is imposed on one employee than on another for the same offense. And importantly, in these cases, the union doesn't need to prove the reason. In a workplace race discrimination case, in some cases, the plaintiffs, the workers, will need to argue intentional disparate treatment. They'll need to argue that there was an intentional decision to treat, black workers differently from white workers, female workers differently from male workers, whatever the case may be. That is not necessary in an equal treatment case. All you need to show is that there was, in effect, a difference in treatment, whether or not there was intention there. And that's a real boon because showing that intent can be the hardest thing in those cases. Here, you just need to have good comparators. So, I think we'll talk later about some of the mechanics of investigating these cases in terms of info requests, all that kind of stuff. But being able to just show, like, hey, this worker was treated differently, given a harsher punishment than other people who did the same thing, is enough to make an equal treatment case. Next up, we have Principle 6, progressive discipline. When responding to misconduct that is short of egregious, an employer must issue at least one level of discipline that allows the employee an opportunity to improve. So, like I said, the point of discipline under just cause is meant to be corrective. The idea is that, and we'll go to the next slide, the idea is that the employer is expected to apply the lowest penalty likely to prevent a recurrence of the misconduct. Basically, what is the least you can do to someone to get them to understand that they need to do better next time? Um, Now, what that progressive discipline standard and set of steps are, whether there can be stacking, whether different kinds of misconduct can stack on top of each other, or whether everything's in its own little silo. A lot of that is going to depend on your particular contract or on the kind of history of practice in your workplace. Generally speaking, you will see something akin to first warning, second warning, or written warning, oral warning, and then written warning, and then a suspension, and then discipline as a fourth step in that progressive process. But that's going to vary workplace to workplace, so you should really make sure to know your contract on that point. A couple other important points to know is that the employer is not required to use progressive discipline where the misconduct is egregious. Again, some things are so patently wrong that no arbitrator is going to make you, walk up the steps. For again, my go-to example today, I guess, is beating up your coworker. No arbitrator is going to expect an employer to simply give a verbal warning for that. And so our final item on our final principle of just cause here is circumstances, mitigating, extenuating, and aggravating circumstances. And these are different considerations. This is to the extent this is a principle, this is kind of a post hoc principle. This is something after you've applied everything else, and there's a determination made of whether the discipline in question was correct as a general matter. These are kind of modifiers you can try to convince an arbitrator to apply in considering what happened. Mitigating circumstances are going to be circumstances that justify a lesser penalty than might otherwise be called for. And again, I think it's important to note we talked about in the equal treatment principle that a caveat to that equal treatment principle is unless there is a good reason to deviate from the same treatment others have gotten. Principle 7 on circumstances are basically all the things that might justify deviating from equal treatment. So mitigating circumstances are factors that might justify not letting someone off the hook, but lessening the discipline they're subject to. So for instance, length of service, spotless or near spotless record, prompt, sincere, and unequivocal contrition. And in the case of a violation that involves substance abuse, participation in a treatment program or counseling. These are all things that you as a committee person could point to say, sure, okay, you got this guy, but you should consider this and maybe go from a suspension down to a second warning or something like that. These are things you can point to make that argument. Conversely, or relatedly, extenuating circumstances are a little different than mitigating circumstances. Extenuating circumstances are things you can point to argue why, sure, maybe this worker committed the act in question, but there are things the arbitrator should consider in order to let them off entirely, that they didn't actually do something wrong, even if they technically committed the action in question. These include poorly communicated orders, inadequate training, insufficient staffing, or frenetic work environment. So, this worker forgot to, put the correct label on this product as it was going out the door, but the line was moving so crazily fast that there was really no way they could do a perfect job. Or their direct supervisor gave them a vague instruction that they were doing their best to follow. Those are extenuating circumstances that could be raised to argue in favor of letting a worker off the hook entirely. And then finally, are aggravating circumstances, which you need to be ready for. These are factors that might justify a harsher penalty than what might otherwise be called for. That includes a poor record of misconduct or malicious intent, belligerence, particularly during the investigation, failure to tell the truth or cooperate, and failure to accept responsibility. So if someone has been shifty, just, refusing to answer any questions, smirking, did something that was clearly intended to cause harm or hurt, those are aggravating circumstances that an arbitrator might look at and say, yeah, this justified a little bit harsher of a punishment than might otherwise have been called for. So those, we did that in a tight half hour. Those are the 7 principles of just cause. And as a committee person, you will be applying those anytime you've got a disciplinary case in front of you. And to practice, we are going to look at a couple hypothetical situations and think about how we can apply the 7 principles we just learned about in those particular fact patterns. So first up, Katrina is a production operator. She had a great work record for 9 years, but just went through a divorce that caused her to have an attendance problem. Recently, her boss started making snide remarks about how others must pick up her slack when she calls off. During quality inspections, a screw Katrina installed was found to be regularly below the required torque reading. The next morning, when she comes into work, her boss tells her that she is terminated for negligence. Was just cause violated? If so, which principles? I'll resist the urge to sing the Jeopardy theme song while you all think about that.
All right, I'm going to work on launching our poll, and we'll see if we can stump Will with this one. You should see the poll, and if anyone's having an issue where you can only select one, just select the one that you think applies most. I'm seeing some variation already, and I'm sure we'll get into this in the answer. No one's going to be graded for your performance. All right, I'll give it a few more seconds. Seeing more people still chiming in. Okay, I'm going to wrap this poll up now, and we can look at this beautiful spectrum of just cause principles that we've got on the table. I'm going to hand it back to Will.
Some great answers, and in a different version of this, I would love to have everybody write a sentence about why they think each of those applies, because I can see an argument for every one of those. I think the most important thing to focus on here is the progressive discipline principle. This is, as it says, Katrina had a great work record for 9 years. As far as we know, this is her first infraction, and they jumped right to a termination on her screw being under the required torque reading. So I think there's a very clear progressive discipline argument here. I think you could also make an equal treatment argument and say, listen, I mean, again, this would come down to what kind of information can you request? What have the disciplinary consequences been for other people who are under the required torque reading? But the fact that her boss is making snide remarks to her all the time might be evidence you can point to say this guy clearly has it out for her and was coming harder than is otherwise called for. And then I think in a lot of these, I think due process is right. If she was called in the next morning and, there's a question of whether she was given adequate time to respond to the charges against her. And then circumstances, there's absolutely mitigating circumstances you could point to here in terms of her difficult personal life struggles that she is going through in this moment. So a lot of answers a lot of things you could argue here, but it seems like we've got a good spread from folks.
Okay, thank you, Will. I'm going to ask Brandon to present the next example. Again, Brandon's a member at UAW Local 897 and an alternate committeeman at the Buffalo Ford stamping plant. And I think we should be able to fix that issue for the future polls so that you can select multiple, by the way. Take it away, Brandon.
All right. Sherry is a fork truck driver. During her shift, she is charged with 2 stop sign violations. She was given a written warning for the first offense and a 5-day suspension for the second. The same day, she saw her supervisor shout, "Careful," to another driver, Jay, who blew through a stop sign. Excuse me, sorry. No discipline was issued to Jay. Was just cause violated? If so, which principles?
Okay, I'll be putting that poll up on your screen now. You should be able to respond, and then we'll see what lawyerly answer Will has for us. Okay, I'm going to give it 10 more seconds or so. Still see some responses coming in. Okay, I'm going to share these results and pass it back to Will.
All right. Yeah. Everybody, I think, struck on one very clear violation here, which is equal treatment. Um, it's a little complicated here in that the lesser treatment occurred after Sherry's discipline rather than before. But I can't imagine that Sherry's case has already gone to arbitration the same day by the time that Jay's lack of discipline is faced. So if I were the committee person here, I would absolutely be bringing up equal treatment and the fact that Jay, the same day, same supervisor, uh, did not issue any kind of discipline against her. There's also an argument, depending on the timeline here, I think there would be questions. But if she was given two stop sign violations after, basically, if she was given both the violations at the same time after she had committed both of them, you would have a progressive discipline argument, at least against the second one. Like I said earlier, the point of discipline is meant to be corrective. And so if they are jumping right to a second offense discipline without ever telling her that she violated it the first time, it's undermining that corrective point. So I think that is something that you could also make an argument for. And then I think a lot of these other arguments, prior enforcement, and others, that would come down to the information you can gather. But certainly it seems possible that if the supervisor is acting this irrationally, you might be able to find some other arguments as well.
Okay, great work, everyone. We've got one more hypothetical example, and then we're going to come back to Brandon. But George, I'm going to ask you to read the next example.
Close this out real quick. All right. Anthony is a production operator. Installing a door handle was just added to his job. He was given a rush training that didn't cover an uncommon model with a different color handle. Since Anthony complained about his job being overloaded, his supervisor has been standing over him. First time he encountered the uncommon model, he installed a wrong colored handle. His supervisor issued a workmanship write-up. Was just cause violated? If so, which principle?
Thank you, George. You should see that poll up on your screen now. I'll give it 30 seconds or so for people to think about their response. Seems like people are thinking hard about this one. I'm going to give it a little bit more time. All right, we will wrap up the poll in a few seconds here. And I'm gonna share the results. Will, what do you think?
I think that the split between fair notice and circumstances is right on the money. I think that you could argue this either way. Certainly, the rush training just added to his job. The poor, poor instruction all speaks to extenuating circumstances. And arguably, since they never actually told him, they never actually trained him on this slightly different model. There's just a straight up fair notice issue here. If he was never told this is how you install a door handle on this car, and they can't discipline him for installing a door handle in that car wrong. So yeah, I think the focus and the results on circumstances and fair notice hits the nail on the head on the primary issue to focus on here. Good job, everybody.
Okay, everyone, great work with those examples. So that wraps up the legal portion, and we're going to get into some practical tips now for certain kinds of grievances that we've been hearing a lot of people are experiencing in their own shops, especially in the big three right now. So first off, I'm going to kick it back to Brandon, and he's going to talk to us about some tips that he puts in place when he's dealing with attendance write-ups.
All right, everybody, let's take off our lawyer hats and put on our union rep hats. We're going to be going over some strategies for fighting attendance grievances. These will give you an idea of questions you should be asking and what kind of information you should be searching for. All right, you just want to make sure that you're turning over every stone that could be overturned to help the employee that you're helping here. Find information that, to be successful with these strategies. Review the number of chargeable absences. If you know you're going into a hearing, just doing this beforehand should be helpful. Review relevant discipline records. Talk to the member, discuss their absences on record. Just check for errors. There's always, mostly always, an error that we can expose the company to. Medical leave, vacation, and other time off. Just having different hands touching an employee's record. Previous disciplinary suspensions, and were there any extenuating circumstances? Right, go to the next slide. Are there absences on the attendance record erroneous? Were any previously served points erroneous? Just look for mistakes that management made to continue to help yourself out to try to get these taken care of. Errors in the write-up itself. Was the write-up factually correct? Was, the date, little things really that can help get yourself in a good stance to get this employee out of trouble or a lesser sentence. And then lastly, did the write-up cite the correct date and time? Again, just going over every little stone to help out here. Next slide. The second strategy is to look for any mistakes management made in how write-ups were issued. Know the write-up procedures in your contract. I mean, going over with your bargaining constantly, just making sure that you have all the tools in your toolbox to get this person off, and has management followed all of them. Now, you want to know more than either HR or that supervisor that's issuing the write-up. So having that in your head definitely helps get that person off. Are there any limits, off-limit times, end of shift for issuing write-ups? By me, there's really nothing that really helps the management side with that. They basically can do what they want with that. Was the worker informed properly? And that's a big one with coaching councils at our shop. They got to put it on paper or it didn't happen. And was progressive discipline followed? Again, going back, was the punishment just? Did they skip any steps with the attendance program? Just anything to try to, blow it wide open. All right, next slide. Again, just what I said in the previous slide, does the punishment fit the offense? Often attendance write-ups are pretty clear cut. They weren't there. The third strategy is what we fall back on. If you don't have a super strong case against the write-up, really just trying to get that person off, or with, little to no help here. Even if we do not have a strong case to get the discipline reversed completely, we can often use circumstances to get the penalty reduced. Is the member record good otherwise? Did extenuating circumstances lead to the member's absence? I got in a car accident on the way to work. My record's clean otherwise. Can you ask the supervisor or HR person to help me out with this one, just so that my record stays clean? Next slide. Strategy 3, does the punishment fit the offense? You want to know what's important to what your grievance. In the case of discipline grievances, there are many different routes to resolutions can take. Some members want to keep coming to work. Some members value a clean record more. Some members want to get away from abusive supervisors. Some members want to stay on their current job. I know people in my shop, there are people that have a half of an AWOL that doesn't go towards their record, and they still want that off. It's just a matter of, I don't want it on my record, just get it off. Well, we want to also look at reduced penalties could look like transferring the member to another department away from the manager, or vice versa. We see little of this only because the company doesn't like to do any more work than they have to. Serving a suspension on paper while allowing the member to work, also that could get tricky in different circumstances, but we have seen it for absenteeism. And just make sure you know what the member grieving the write-up wants most out of the resolution. That's a big one, because going forward, it's what the member wants.
All right, thank you, Brandon. That was great. And encourage people, when you're thinking about which of these strategies to use, to mix and match. You can use multiple strategies in one case, and I'm sure a lot of the time you will. Now I'm going to pass things off to George Freeman, who's the shop chair for Allison Transmission in Local 933, to tell us a little bit about how he handles insubordination write-ups.
Thank you, Becca, and welcome everyone. Disclaimer. This is a bit of a disclaimer we want to give before getting into how to grieve insubordination write-ups. Always remember, work now, grieve later, unless the order places you in imminent danger. That's what the whole disclaimer. Unless the order places you in imminent danger, work under protest now, grieve the order later. Gather all information you can. Again, we're going to start with some places you should look for information on the case you're dealing with. Interview the member for a detailed account of events. Take notes. Interview any witness for their detailed account of events. Take notes as well. Notes. That's very important. Review the member disciplinary record. Review other disciplinary cases involving the same supervisor. That's important because then again, you pull up that supervisor information, you can see a pattern that he or she has placed upon a certain member. So follow-up is very important on that. Next slide. Strategy 1, standards for insubordination. Now we're going to get into strategies you can use to fight the write-ups. Remember, you can use multiple strategies in one case. They're not mutually exclusive. The first strategy is prove the member's behavior does not meet the standard of insubordination. An employee refusal to work or obey must be knowing, willful, and deliberate. Mere negligence in performing one's duty is not insubordination. The order must be given both explicitly and clearly so that the employee understands both its meaning and its intent as a command. It's very important. All right, Papa just showed up. Okay, hold on. Go back to the last one, please. The order must be both reasonable and work-related. Next one. The employee must be aware of the consequences of failing to perform the work or follow the directive. That means the supervisor must tell you, if you don't do this, this will happen. If practical, the employee must be afforded time to correct their purported insubordinate behavior. Merely asking a supervisor about an order or directive that was given does not surmount to the level of insubordination. Case in point, and this happened in our plant. At a start of shift meeting at 3 p.m., the manager said he wanted the employee to alternate his breaks. The employee protests. They called security and had him escorted out. They did not give him a chance to correct himself or even give him the chance to violate the supervisor order. Next, recently a young lady was told by her supervisor that she needs to move her job assignment. She asked him, why am I being moved? I thought this was a seniority shop. She was wrote up right then and there, just by merely asking that question. Next slide. Proving a write-up is wrong. The next strategy is to look for any errors in management case for write-ups. Error in the reporting of event. Can management prove their story with witness? Is there evidence to the contrary? Witnesses, text between worker and a manager. Error in the write-up itself. Does the incident fall under a different shop rule with lesser penalty? In our shop, sometimes they use shop rule 14, refusal. But a refusal to do it is just the same as insubordination, but I'm sure all shops are different, but shop rule 14 is used where you might get 3 days. Where insubordination, we can be looking up to a discharge. Next one. Is the boss the problem? The third strategy is one we can use when we want to go on attack against a problematic supervisor. We don't want to be caught on the back foot fighting wrongful insubordination grievance. When possible, we want to get to the root cause of the problem. We can go on the offense if the supervisor's behavior warrants a harassment grievance. Does the other members commonly have issues with the supervisor? Is this member being picked on? Have others been let off the hook for the same behavior? Did the event occur during a particular tense time? Did management aggravate the situation? Was the supervisor provoking the employee? All right, next slide. Remember, even if manager is able to prove guilt, you can argue the punishment does not fit the offense. Remember, you can always try to negotiate the penalty down. If we do not have a strong case to argue, we can use what we have, try to get some resolution. You should always talk to the member about what's most important to them first. And what that means pretty much, can we get something less? What can we do to keep you in the building? Because it is hard to fight for a member when they're outside the building. It's best to keep the member inside where we can fight that offense and try to get their record clean. Becca, appreciate your time.
All right, thank you, George. Now, before we get into Q&A, we want to share some resources where you can keep learning more about grievance handling and contract enforcement. So first, we have a few great books for sale on our website, including this deep dive into just cause, and there's a broader guide also on a lot of different topics that you might encounter as a union steward. Second, I want to encourage you to check out our previous and upcoming classes, which are all on our website. So we have a couple recent webinar recordings, including legal rights of union stewards and dealing with difficult supervisors, and both of these are going to be really good complements to what you learned today. Now, speaking of upcoming events, we have a class coming up in the Detroit area. It's going to be at Local 1264 in Sterling Heights, and we hope that you'll join us. It's called Skills to Strengthen Your UAW Local. So if you're trying to build up your local standing committees or get members coming out to more union meetings, or you're educating the membership on your contract, or even getting members mobilized around some issue in your shop, this is the class for you. And some of you here might be thinking, now I've been doing that for years, I don't need to take a class on it. But I want to tell you that this is actually the class for you too, because we want your expertise in the room. This is all about UAW members sharing your firsthand knowledge. So everyone's going to get something out of this class, and I can promise that, because if you attend, you're going to get a free drink ticket for the social afterward. And the Lions game isn't on till 8, so stay a little while and come socialize with other UAW members who are fighting the same fight and trying to strengthen their locals too. We've still got some flyers left if you want to help spread the word about this event and invite other members. So just respond to the number that was texting you reminders for this training if you'd like some flyers for this upcoming class in Detroit. Next up, I want to tell everyone that we have a network of grievance handlers in the UAW that we're building. And if you are a steward or a committee person or a grievance handler on this call, you should expect to hear from a member action organizer this week. We want to share successes and challenges as well across shops, because we believe this makes a stronger union when we share our lessons. And then for our final poll of the day, we want to get your feedback on what kind of training you would like to see next. So I'm going to launch a poll that should give you a few options that we're thinking about. And if you have another idea, you should be able to put that in a little text box in the poll. All right, launching that right now. You should be able to see it up on your screen. Okay, I'm going to give it a few more seconds, and then we're going to get into Q&A. And I see some questions in the chat. I see some questions in the Q&A box. This is all fine. We'll respond to all of these questions. Okay, thank you everyone for your feedback on our next training. Now, let's get into Q&A. I'm going to stop sharing my screen so that we can see our presenters. If you want to direct your question toward anyone in particular, let us know. Now, first, I'm going to go back to a question that was coming up during the training, because I promised people that I would in the chat. Around the question about bringing up more information after a discipline has already been issued to increase the penalty, we had the question about does that go both ways? And what I'm assuming was meant there is they're wondering, after the fact, if we discover new information, can we get the penalty changed in our favor? So Will, I'm going to pass that one off to you.
Sorry, can you restate the question? I'm not sure I understood it specifically.
If we, through an investigation after a penalty's been issued, discover new information, can we try to get the penalty decreased?
Well, I think this speaks to kind of the difference in relationship. When the employer, the short answer is yes. When the employer is in that situation, is learning new information, that nothing has changed for them. They implemented the discipline is in place, and then they're going back and re-upping. The position we're in is we have filed a grievance, and we are maybe taking that grievance to arbitration. And so if we're discovering new information, we're probably revealing that information in that arbitral process. And so part of that whole process is to decide whether this was just cause or not and whether we can decrease that penalty. Now, if it's a question of if we learn something after that whole involved process, I mean, you can make that argument, but it's not the same situation where like the employer is just doing it versus we're trying to convince the employer to do something. Certainly, if you can convince an employer to lessen a discipline, that's going to be fine because the only way an employer can be called to the mat for increasing a discipline is through a grievance. And if we're getting them to lessen it, we're not going to file that grievance.
All right, that makes sense. So investigations generally work in our favor, and that's why we do them. Here's another question we're getting. It looks like, based on the attendance section that Brandon was leading, someone's curious, is a wrong timestamp really enough to get a whole write-up removed? I'm curious if anyone here has experience with a case like that, if management just messes up a kind of clerical error.
Oh, I'll take this one. I definitely can. I mean, I'm not gonna speak that, it will, but it definitely can. Clerical errors, just making sure we're going through it with a fine tooth comb, to try to get that person off. Definitely worth a shot. Definitely worth a shot.
Thanks, Brandon. Anyone else want to add to that?
Hey, Becca. In our plant, we call due process industrial civil rights. So that's what we call. My committee, he's on here, and I don't use due process, but I said you violated person industrial civil rights. So that makes it a little bit deeper.
I love that lingo. All right, I'm reading through our questions and trying to find our next one. Here's another one that we got during the training. Management holds union reps to a higher standard than the average worker. Is this permitted? Now, if this person has any specifics, I'm definitely curious to hear about that, but I'll let Will give an initial answer and others feel free to chime in after.
Yeah, my initial answer is no. The employer cannot hold a union rep to a higher standard than any other member, because they're basically holding them to a higher standard because of their union activity, and that's a violation of federal law. So if you are experiencing that, and in fact, there are certain circumstances where the union rep, the steward, the committee person is entitled to more deference from the employer than the average worker when they're standing in the shoes of the union. And for instance, in an investigatory interview or in a hearing. So certainly if you're in a situation where a steward is being held to a higher standard than their average coworker, that's a violation. It should be grieved and maybe a ULP should be brought.
All right, thanks. Well, George, Brandon, any firsthand experience to add to that?
I 1000% agree with Will. But when you have a lot of eyes on you, supervisors, members, just maybe going into a zone where you're not supposed to be, not crossing a crosswalk in plant, eyes will be on you, and there will be people talking, hey, did you see Brandon go into that red zone without, a cause to be in there? So just be wary of that.
Yes, Becca. In my case, it's kind of like we don't adhere to certain shop rules because we're always advocating for the member when we're on the floor. Even during shop committee day, when we have most of our bargaining reps, we try to make sure we get out to the plant where everybody is. And labor doesn't like that. Labor consider that wolf packing. And which is wolf packing is not in the contract. Wolf packing is not a shop rule. But we want to make sure the members see us out there. We are actually policing the agreement.
I think that's just management showing how much it upsets them to see the union out on the floor. All right, thanks, George and Brandon and Will as well. Here's another question that we have, and this is kind of about how you argue these cases in practice. If there are multiple just cause principles that apply, which we definitely saw in some of these examples, do you want to argue the strongest one or do you want to argue all of them that apply?
Yeah, quickly, I think you want to argue all of them, but then it becomes a question of structuring. I would lead with your strongest argument and then kind of go in descending order to some extent. So start with, what is the principle that like is most obvious, most clear, lead with that. And then to the extent others apply as well, bring those in. But lead with your strongest foot, but make sure to get all the arguments that you think are worth bringing into the argument.
Thank you, Will. Anyone have anything to add to that? No? Does that square up with your guys' experience? All right, I'm seeing that. We also got a question looking for another example, and kind of practically, how do you prove a case about equal treatment? George, Brandon, does either of you guys have an example about equal treatment that you managed to prove that comes to mind?
Not off the top of my head, but that would basically go back to note taking, even in the insubordination aspect. You know, since we have gone electronic with our grievance filing, it is easy for us to find. We can type in the supervisor name, all the grievance would populate. We can type in the employee's name, it would populate just well. Then we can cross-reference. And then, we can see how Kathy got treated better than Susie, Jim got treated better than John. And then we would make our argument after that.
Thanks, George. That makes sense. All right, we're going to take a couple more questions. These have been quicker responses, so we're getting through a lot of them. This one's about attendance cases, and this might differ by employer, but I believe this member's at Stellantis, and she's wondering which pieces of documentation carry the most weight in attendance hearings: Sedgwick letters, doctor's letters, or attendance records. Now, neither of you guys is at Stellantis, but do you have any experience that might point to what evidence helps you argue attendance cases most? And Sedgwick is the contractor that deals with leave at Stellantis.
So we also deal at Ford, we deal with Sedgwick, and they promised a seamless transition, and it's been nothing but that. All those issues congruently, they work hand in hand. I don't think one holds more weight, but for those Sedgwick cases, you want to make sure that you have all the paperwork sent into where it's got to go to HR, medical, etc., to further yourself along and not, have to have your case in somebody else's hand and waiting for a response.
Hello, Becca. We deal with Cedric as well. And I'm going to just put it out there. Cedric works for who? They don't work for us. They work for the company. So that means that whatever the company wants, they can pretty much get from Cedric. And then I see someone talking about attendance and doctor notes. Pretty much, even at our plant, I'm sure some have a no-fault attendance policy. Doctor notes doesn't mean anything. You just have to have the time to cover it.
Thank you, George. Thank you, Brandon. I'm looking for our next question here. Okay, here's one that I'm going to call out, even though it's not necessarily related to just cause, but because I've been hearing a lot, especially at Ford, that members are struggling to take leave, struggling to take personal days because the company's cracking down. Now this person's wondering if a manager is complaining and bringing up FMLA to members and labor. They said, I know it's illegal, so I'm guessing this, is bordering on harassment. What kind of grievance would I write to put a stop to this practice? Does anyone have experience with something like that? A member getting harassed for using their FMLA?
Uh, Will speaking. I think Will is speaking. He's muted. You
Go ahead, George.
Okay, thank you. Basically, all I can say that is offensive itself. Is it violating their HIPAA rights? My thing would be I would be in contact with the Department of Labor. Because the grievance is only going to take you so far. The Department of Labor is the enforcement of that. But then under this current administration, I don't know how the Department of Labor is going to work. Just like we don't know how the NLRB is going to work. But still, again, you have outside resources, and I would say Department of Labor, will you free to correct me? If so, I understand.
You're absolutely right that, I mean, yeah, people can't be retaliated against for using their FMLA leave. They have a right to use it. They have a right to ask to use it. So there's definitely a violation there. It comes in terms of grievance. I mean, I agree with George that this administration, I wouldn't trust DOL to do their job. But a lot of contracts, and I don't know the specifics of this person's contract, have provisions about generally following the law or, some kind of catch-all provision that illegal conduct by the employer or by the union for that matter can also be grieved. So I would look at the contract to see if there's a hook there to basically say, hey, the employer is violating the FMLA, and in so doing, they're violating the contract in this way.
All right, thank you, George, and thank you, Will. So it sounds like even if management hasn't necessarily violated someone's leave, questioning and harassing them about it can definitely be a violation both of the contract potentially and of labor law. Okay, this is the last question we're going to address today. And the question kind of has to do with settling resolutions for grievances, I think. So the question is, what if what the member wants out of a resolution would set a bad precedent going forward for other members? Has anyone ever addressed that situation? Will, you look like you have something.
I've got thoughts on this, but I wanted to, if Brandon or George have thoughts on this, because I think their perspective might be, I mean, I'll give the legal answer, and then our committee people can give the practical, real answer. As a committee person, your duty is to the union. Your duty, the union is a collective endeavor. You're representing everybody, even when you're just representing that one person. You have a duty of fair representation to each member. But part of that duty of fair representation is balancing the needs and interests of everybody against the needs and interests of an individual person. And so in the same way that, you as a union rep are within your rights to decide pursuing these agreements is not within I've done my due diligence, I've done my investigation, I'm not acting arbitrarily, capriciously, or discriminatorily, and I don't think that this agreement should be pursued. You're within your right to do that. And similarly, when it comes to settling a grievance, the grievance belongs to the union. And so if there's a settlement that would be detrimental to the contract, to the shop, to the members as a whole, even if it's good for this one member, doesn't mean you have to agree to that. Now, how to put that in practice? I don't know. And I'll leave that to George and Brandon to speak to.
Okay. Will kind of took some of my words. The grievance belongs to the union, not the individual. When selling grievance, there are certain factors we look at as well. We look at the employee's history, and then we look at precedents also. Has precedent set for this particular event or violation? So we look at that, but then again, this is going to sound a little harsh. We don't need the member's permission to settle the grievance. That we don't. But ultimately, are we looking out for the best interests of the member? Some of them don't like that. I don't like the way you settle this grievance, but we have to look out for the member and the membership as a whole. And sometimes that is a hell of a balancing act. I can sleep well on decisions I have made, but the balancing act is horrible because we don't know which side is going to teeter-totter. But we as bargaining reps, we do our best every day. We got the most unthankful job, but we like what we do. But remember, the grievance belongs to the union.
Thanks, George. Any final words, Brandon?
Yeah, I mean, I always have, if something doesn't go somebody's way, I usually take a chance to educating the member to why is this not a grievance? Why is this something that's going to handcuff our bargaining reps to bargain for and for everybody? And just really just pulling it all together and just say, instead of saying, I'm sorry, that's not a grievance, and leave it at that. Usually circling back telling them why. Go get some a leaflet, something that's going to help the member understand why it's not a good grievance to pursue.
Thanks, Brandon. Appreciate you adding that. Always a good idea to use every grievance as a learning moment for the member that's involved. Okay, well, with that, I want to give a big thank you to our presenters, Will, George, and Brandon, and a thank you to everyone who came out and spent some of your Sunday afternoon with us. We hope to see you on a future class, and maybe we'll see you in Detroit on October 12th if you're nearby. All right, solidarity, everyone.